This is the Speaking of Writers podcast. I'm Steve Richards. Whether it's the overturning of Roe v. Wade in Dobbs versus Jackson, the presidential immunity decision, or President Biden's proposals on reforming the court, the Supreme Court holds a central role in American politics. These issues and other controversial cases before the court give many observers the impression that the court has only recently become excessively politicized and that we must return to a time when the court held unbiased judicial authority. Law professor Stuart Banner, in his new book, The Most Powerful Court in the World, A History of the Supreme Court of the United States, offers a comprehensive history of the court from the 1700s to the present, demonstrating that these criticisms are nothing new since the nation's founding. The court has always been called overly political, and presidents have always sought to nominate justices who will decide cases in favor of their political preferences. Stuart Banner is the Norman Abrams Distinguished Professor of Law at the University of California, Los Angeles. A former clerk for Justice Sandra Day O'Connor, he's the author of several books about the history of the American legal system, including How the Indians Lost Their Land, The Death Penalty, The Decline of Natural Law, Speculation, The Baseball Trust, and American Property. Happy to have for the first time on this podcast, Stuart Banner. Welcome.
Well, thanks, Steve. Thanks for having me.
So, why this book for you?
Well, uh, I've been sort of peripherally involved with the Supreme Court for many years, and every once in a while, people would ask me to recommend a good history of the Supreme Court, and I was always at a bit of a loss, because there are lots of books about the history of the court, but uh, they virtually all of them are written with a political slant. Virtually all of them are written. The author wants to either praise the court for some decisions or criticize them for others. And then the books are most books about the history of the court are. They're really just summaries of the court's decisions. They don't really answer the kinds of questions that you let off with. So, just about anything that you could say about the court today prompts questions, so for example, the notion that the court decides politically controversial cases. Well, has it always been like that? If not, when did it change? Why did it change? The process for appointing new justices is always controversial. Has that always been that way? If not, what was it like before? Why did it change? And so on. So just about anything you could think about, or that I could think about the court, it's I was just very interested in its history, and so I thought, okay, here's an opportunity to fill a gap, to write a straightforward, non-political history of the court, just trying to explain what was it like, and to talk more than just about the decisions, to talk about a history of things like the sorts of people who become justices, the processes by which they're appointed, the court's role, court's sort of interaction with the rest of the government, with the public at large, even things seemingly as mundane as the court's physical surroundings. The history of sort of the building that it sits in, and the how they just communicate with each other and things like that. All of that just seemed just really interesting to me, and seemed like a gap worth filling.
You refute several dubious ideas in this book. I want to touch on a couple. The overemphasized impact of the Chief Justice. Talk about that a little bit.
Well, so here's another difference between my book and other books, and that most books are organized chronologically by Chief Justice. So a chapter when, say, John Marshall was Chief Justice, and then go proceeding with the other Chief Justices. But that is, I just don't think that's a sensible way to think about the history of the court. Just because the Chief Justice is no more powerful than any of the other justices. They each get one vote. I mean, the Chief Justice has some administrative responsibilities, but that's it. And so, a lot of the uh, sort of dividing lines in the court's history they just don't coincide with the replacement of one Chief Justice by another. So just to pick an example that in from recent times, people often use the phrase the Warren Court as sort of the shorthand for the liberal mid 20th century court that decided, famous liberal cases like Brown v. Board of Education, and they use the Burger Court to refer to its conservative successor. But Burger, not Warren, was the Chief Justice when the court decided some of its most famous liberal cases, including Roe v. Wade. Or if you want to look at another example, if you're interested in the role of the court during the Civil War, it wouldn't make sense to divide by Chief Justice because Roger Taney, the Chief Justice, died right in the middle of the Civil War and was replaced by Salmon Chase. So if you want to understand the role played by the court in the Civil War, dividing by Chief Justice would only obscure your understanding. It wouldn't help. And so, I think the idea of organizing a book by Chief Justice, it's I think it maybe it comes from histories of the presidency. So if you wanted to write a history of the presidency, it would make perfect sense to have a chapter on, divide the chapters according to the particular presidency, because each new president changes the direction of the executive branch. But that's not really so with the Chief Justice.
Let's talk about process a little bit. How do the justices, Stuart, and their teams work to reach decisions?
Well, if you're asking about today's court, I mean, things were different in the past, of course, but today they work like they're like nine little law offices that largely work separately. And so the justices and the law, just each justice has four law clerks, and the justices and the law clerks will read the briefs and talk about the case. And then when the court goes to holds oral argument, that's the justice's first occasion to discuss the case with each other, is actually at oral argument while they're questioning the lawyers. And so it's a common thing to see that during oral argument that the justices will actually be arguing with each other about the case, but through the medium of asking questions of the lawyers. And so the lawyers just were almost like a conduit for discussion between the justices. And then after the argument, the justices will have their conference, and that will be their first real opportunity to discuss the cases together. And they'll each give their point of view and take a tentative vote, and someone in the majority to be assigned to write the majority opinion. But the vote's just tentative, and it's not unusual for people's votes to change once they see the text of an opinion.
Is there a period that you really enjoyed researching and writing about a certain justice?
Well, I'll tell you that one of the things that I just thought was the most charming thing was there's a chapter in the book about the early court, the justices riding circuit. So in the late 1700s and for most of the 1800s, the justices actually spent most of their time not in DC, but they spent most of their time acting as trial judges, riding around the country. Each justice was assigned a circuit, a particular part of the country, and they would ride from city to city, conducting trials. And this was a time when transportation was very rudimentary. They were riding by, riding horses, and it took a long time to get from one place to another. And in a lot of places the hotels were not very nice, and so they complained constantly. They hated it. And I just it's they I love writing that chapter because from the justices' correspondence, they really come across as like recognizable human beings. I mean, they exhibit all the same impatience and exasperation that we would show if we had to, like, ride through the woods on a horse, to over many days to go hold a court in some podunk town in the middle of nowhere. So that actually was one of my favorite chapters to work on.
Stuart, what was your research like for this book?
Yeah, so the about half of the justices have left papers. have collections of papers. The more recent ones, papers aren't available for the most recent ones. They're not available yet to researchers. And then a lot of the early, there's no collections of papers for a lot of the very early justices. But for most of the ones in the middle, there are papers, and they're scattered all over the country. The Library of Congress holds the biggest chunk of papers, but I went all over. I tried to go to all of the libraries that hold collections of justices paper, significant collections of justices papers. So there's some justices where there'd be like 3 letters or something like that, and I'm not going to go make a special trip just to read 3 letters. But I went all over the country to do research in the justices papers. Also, the presidential libraries were a very important source for me because they've got the records of the presidents, obviously, but also people who worked in the Justice Department and other officials who were involved in selecting the justices. So a lot of the book is about the history of how new justices were chosen, and so I went to all the presidential libraries, which was very helpful.
I'm going to ask you to put your Chief Justice John Marshall robe on for a moment here, Stuart.
Yeah.
What do you think how would he feel about the court today and its role?
I think in some respects it would be instantly recognizable to him, right? And so the the critiques of the justices for reaching decisions based on political grounds rather than the law, that's exactly how his decisions were criticized. He would have recognized that right away. The idea that presidents would try to appoint justices who would implement their policies, again, that was exactly the same. So in some respects, I think he would feel right at home if he saw today's court, but in other respects, it would seem like a completely different institution. I mean, the most obvious thing is that now the justices, they're full-time residents of Washington, and they have this big imposing building. But in John Marshall's time, they were only in Washington for a couple months out of the year. They spent most of the time out, like I said, out riding circuit. And because they were only in Washington for part of the year, they didn't have their own building. They occupied a room in the Capitol. The current building, which is the court's first building, was only built in the 1930s. So the court didn't have its own building. The justices worked in their own homes. They didn't have because they didn't have offices. Well, actually, I shouldn't say they didn't work in their own homes. They didn't have homes. Because they were only part-time residents of D.C. So they actually would come and they'd stay in a boarding house together. So they would all room together in boarding houses, and they would go hold court during the day, and then at night they'd eat dinner together and talk about the cases. And so the correspondence of the justice from this period, it shows there was like a lot of camaraderie. They would enjoy spending time together. So in those respects, I think Marshall would be astonished to see the court today. But in other ways, like I said, I think it would be instantly recognizable to him.
Does the rising power and presence of the Supreme Court over the years directly coincide with the increased prominence and power of the federal government?
Well, yeah, I mean, I would quarrel a little bit with the premise of your question in that the court was extremely powerful right from the start. So this was a deliberate choice, by the when the Constitution was written, right? I mean, the Constitution was written to divide power between the state governments and the federal government, and to limit the and even to give rights to individuals that neither government could limit. And the Supreme Court was the institution that was ultimately going to decide when those limits were crossed. And so, right from the beginning, the court was extremely powerful. A lot of the court's early decisions really didn't depend on some of the court's early decisions were testing the limits of the power of the federal government, but probably more of them were testing the power of state governments, right? Where someone was claiming that what a state government had done exceeded the state's power. So in that respect, I would say that the amount of power the court exercises, or the court's prominence in sort of the public mind in that respect, is really not linked to the rise in power of the federal government. But in another respect, I would say yes, they are linked. And that is, a lot of what the court does today is to interpret federal statutes. And, the story of the last 100+ years has been Congress more and more exercising its power through statutes, doing things that were governing areas that were formerly just governed by state governments. And so, in that respect, I think you're right that the court's prominence in public life is connected to the rise in power of the federal government with respect to the states.
Yes, Stuart, you mentioned the court established to judge laws as to their constitutionality to arbitrate cases between states. How did it go from
Mhm.
referee to player over the decades? And do you think it has?
Well, I'm not sure what you mean. No, I don't think. I mean, it's a referee. It's still a referee, and so it can't. The court can't. The court can only decide cases that are brought to it, and it just decides who wins and writes an opinion explaining why. That's what it's always done. The nature of the issues that are controversial has changed over time, right? And so, in 1800. Abortion was not a controversial legal issue. Affirmative action was not a controversial legal issue. So there weren't cases about those subjects, but there were controversial legal issues in that time, and the court decided cases involving them. And so a lot of the early courts cases involved slavery, either directly involving slavery or indirectly involving slavery, in the sense that everyone at the time was aware that whenever the court upheld the federal government's power to do anything with respect to the states, slavery was always in the background, because the slave owners were always worried that the federal government would at some point intervene and try to either make slavery illegal or make it unprofitable by taxing it, things like that. And so the federalism cases, the cases of the early courts federalism cases, that is, the cases testing the boundary between state and federal power, were always indirectly about slavery. And of course, slavery was a super controversial issue at the time. So the court has always decided controversial, politicized questions. The farther back you go in time, the harder that can be to see, because yesterday's controversies just aren't controversial anymore, right? No,
Yeah.
there's no controversies over slavery anymore, and so everyone thinks it's bad, and it's easy to miss how politicized the court's decisions were back then.
All right, the big question. Is it time for term limits for Supreme Court justices, do you think?
Well, yeah. So if you asked me, would it be wise to have term limits? Or either term limits or an age cap.
Age. Yeah.
I would say yes. The as far as I know, we're the only country, or one of the at least very few countries, that has life tenure for judges. It's been a recurring issue over the years. I mean, even apart from the political aspect of it, there's been a recurring issue of Supreme Court justices who uh, start declining mentally, but remain on the job. Often they don't realize that they are themselves declining. I mean, that's not true of any of the current justices, but it's been a recurring problem. So there's an apolitical, neutral reason to have term limits, and then also, in political terms, it would make the court. The justices maybe more reflective of the country generally. And so, yeah, so I would be all in favor of term limits. The difficulty is that the Constitution says that they serve for life. And so people disagree about this, but it's probably more likely than not that you'd have to amend the Constitution to get term limits. And this has been a recurring issue, because the question of having an age cap or term limits is not a new question. People have been debating this for a very long time. The problem is that whichever political party currently holds power, currently has a majority of the court, doesn't want term limits. Doesn't, you know, because they like the current situation, right? And so in the mid 20th century, when the court was more liberal than the country as a whole, when the court was to the left of the country, but in the mid 20th century, it was conservatives who wanted term limits, and you know, it was Republicans who wanted term limits, and Democrats were against it. And of course, now it's exactly the opposite. So, you know, to amend the Constitution requires a supermajority. You know, you need to have, you know, way more than 50% of the people to favor it, and it's just unfortunately just very unlikely. Now, law professors come up with creative plans to say, well, they'll, you know, workarounds to so that they'll, you know, ways getting around the life tenure problem. I don't know. It's going to be difficult.
You mentioned law professors. You're a UCLA law professor. How did you become a writer?
Well, it's part of the job of being a professor. Professors write books. I was a lawyer for a few years, and you know, I found myself you know, taking the subway to work and reading history books for fun on the subway. And then I started to think, well, wait a minute, you know, maybe I could write these.
And what would you like readers to take away from the most powerful court in the world?
Well, I guess if anything, just to realize that today's debates about the Supreme Court are nothing new. You know, it's basically been there's been similar debates uh, 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 from the beginning, from the court's beginning. So it's been going on for 2 centuries, and you know, unless something catastrophic happens, it'll probably keep going on for another 2 centuries.
The book is The Most Powerful Court in the World, A History of the Supreme Court of the United States. The author is Stuart Banner. It is on Oxford. It is available now. And if your indie bookstore doesn't carry it, make sure they order it. And Stuart, thank you so much for joining me.
Well, thanks again for having me.
And make sure you hit the subscribe button on this podcast. This is the Speaking of Writers podcast. I'm Steve Richards.